Hello, everyone. Welcome to our HSBA Senior Counsel Division monthly coffee hour. Today we have Mr. Scott Makuakani presenting today on asset protection and estate planning. Scott is a graduate of the William S. Richardson School of Law at the University of Hawaii at Manoa, Duke University, and Ka'u High School. He has been practicing estate planning and trust law in Hawaii since 1983. He is past chair of both the Probate and Estate Planning Section and the Estate and Gift Tax Committee of the Hawaii State Bar Association, and he currently serves on the board of the Senior Counsel Division as our current president. And without further ado, here is Mr. Scott Makuakani.
Thank you, Desmond. Aloha, everybody. Good noon to you. Thank you very much for joining us. We're going to be talking about asset protection and estate planning on a fairly basic level. And I'm going to try and leave some time at the end for questions. So if you have questions, just go ahead and enter them in the chat or however you want to do that. And then with about 15 or 10 minutes left at the end, we'll devote those, assuming we have questions. And if we don't, that's fine too. Well, when we start talking about estate planning, a lot of times our clients know two things. They know they want to avoid probate, they want to avoid taxes. And those are important things. We do definitely want to help our clients do those things, but there are some things that I think are even more important. And so even when we think about our own estate planning, I think we need to take these things into consideration as well. So as far as I'm concerned, the foundation of estate planning really is control. It's keeping control in my hands as long as I'm alive and well, and then transferring control to the people that I trust, that I feel the most comfortable with, making decisions for my stuff, making decisions for my medical care, all of those kinds of things. But to me, control really drives estate planning, whether you're talking about just passing your stuff on, whether you're talking about asset protection, control really is king. Next step up the ladder in this planning pyramid is providing for me. Oh, and my spouse. Now, I have my dear spouse there in parentheses, not because she's not important. She's very important. But it's for the same reason that when you take a plane trip, during the safety briefing, they tell you about the masks. And I've never seen the masks other than during the safety briefing. I hope I never do, but I know what to do when they appear. I grab the mask and I put it on the person next to me, right? Well, no, that's not what they tell you. They tell you to put it on yourself first so that you're in a position to be able to help the people sitting around you. And estate planning is kind of like that. You got to take care of yourself in order to be in a position to take care of the people who, figuratively speaking, are sitting around you, your spouse, your kids, your other loved ones, maybe even your pets. A lot of people draw their fine, furry, feathered, or finned friends into their estate plans, and there's no reason not to. Our pets become family members, and their needs really do have to be taken care of in connection with our estate plans as well. Next step up the pyramid is providing for other family members. And then the tip of the pyramid is minimizing those taxes and expenses. It's taking care of probate avoidance. It's taking care of making sure that no unnecessary taxes get paid or have to be paid. So that's important, but it's not what should be driving the rest of the estate plan. So given that pyramid, let me propose this definition of estate planning. First of all, I want to control my stuff while I'm alive and well. And I've never had anybody argue with me on that point. Control, number one. Next point, I want to plan for me and my loved ones if I become disabled. Now, if is a very small word, but when it comes to the prospect of disability, all of us need to face up to the fact that probably about 70% of us hearing my voice right now are going to spend some period of time completely disabled and needing some kind of care before we die. So the odds aren't great for any of us, unfortunately, So disability planning is something we definitely need to take into account in our estate planning, and it's something we need to encourage our clients to do as well. And then ultimately, I want to give what I have to whom I want, when I want, the way I want. And when I die, and I'm sorry to rub it in here, but this is 100% probability. It's not a question of if, it's a question of when. When I die, I want my stuff to go to the people I love without unnecessary cost or delay or loss of privacy. So how do we do that? Well, dealing with our stuff when we die can come in a whole variety of approaches. One is essentially do nothing. Rely on the state's estate plan, which is our Intestate Succession statute. Another is joint tenancy, tenancy by the entirety. And we'll talk about some of the pluses and minuses of those two approaches, but they're not necessarily the complete approach that we want to urge on our clients or that we want to adopt for ourselves. Next, beneficiary and POD, meaning pay on death designations, whether it's investment account, bank account, life insurance, retirement plans. Those are something that we're going to want to be very careful to complete ourselves and to help our clients complete as well. Will-based estate planning, we're all probably very familiar with that. And then finally, trust-based planning. And we'll talk about some of the pluses and minuses of all of those things. So let's start with intestate succession. Intestate succession is essentially doing nothing and just relying on the state statute that says that your stuff will pass as a general rule to your heirs. And that may be good, but it may not be that great of a result for you. So what I'd like to do is review the two-finger test. I've shared this before in these sessions. And so if you haven't seen it and you would like to participate, now is your chance. So take two fingers and then place them on the inside of your opposite wrist, right about here. And hopefully you feel this bumping sensation. Now that means you flunked the two-finger test. But what it means in the legal sense is you don't have any heirs. As long as the bumping continues, your heirs are still to be determined in the future because your heirs are the people who are entitled to your stuff when the bumping stops. So if you've passed the two-finger test, congratulations. I'm delighted to know that. But just know that if you depend on intestate succession as your primary estate plan, once you know that you passed the two-finger test, you also know that your plan really is filled with uncertainty because we don't know who's going to outlive us. So that's something that may be a way that we can encourage our clients to get off the dime and actually get estate plans done by pointing out that doing nothing can result in some pretty gnarly consequences. Among them, mom's nightmare. This is a true story. Mom found out that husband was having an affair. Well, mom wanted a divorce. So mom and dad divorced. Once the dust was settled, the property was divided up. Mom, unfortunately, died. Now, mom and dad had one child. Everything mom owned went to child by way of intestate succession. And that's probably what mom would have wanted. So far, so good. But tragically, child died not too long after that. So when child died, child unfortunately didn't have a will either. Her estate plan was the intestate succession statute, which left everything to her dad because she wasn't married. She didn't have any kids. Dad, as you have probably already guessed, subsequently dies without an estate plan in place. And the intestate succession statute transfers everything to his new wife. Now, do you think mom might have been spinning in her grave at that point, knowing that her stuff eventually ended up in the hands of the woman who sort of took her husband away from their marriage? Probably so. That it's very unlikely that that's the result that she would have intended. So just a good cautionary tale to be able to share with clients. Now, interestingly, If all of those individuals had had simple wills and just left their stuff to the person who was logical to receive it, probably would have been the same result. If mom wanted a different result, she would have had to do a little bit different kind of estate planning. And by the end of this session, we'll all have an appreciation for what that is. If your stuff passes by way of intestate succession, of course, it's going to have to go through probate. And probate has all of its horror stories about how long it takes, how expensive it can be, how it becomes a forum for a fight among family members, how it's a matter of public record. So anybody who wants to can go down to the courthouse and get all kinds of information about you and your family and your stuff and do who knows what with that information. So probate has a lot of negative aspects to it, and generally it's a wonderful thing to avoid. Now, although most clients fear probate, sometimes more than anything else, they don't always know that it's not all that bad in most cases. It's just, it has the potential to turn very bad very quickly, and so it is a wonderful thing to avoid. Okay, so an alternative to doing nothing is actually putting other people on title to your stuff. Joint tenancy is one approach, and some families think, wow, what a great idea. Mom and dad just put the 3 sons on title to everything they own, and their estate plan is written. They didn't have to go see a lawyer. Hallelujah. Well, let's imagine mom and pop and their 3 sons, and let's just pick names at random. Oh, how about Mo, Larry, and Curly? So Mo, Larry, and Curly are signed on to all of mom and dad's assets. They're put on title to the house, they're put on title to the bank accounts, and mom and dad generally are still in control, and everybody recognizes that. But they have their, what they think, brilliant estate plan in place. And everything goes well for 5 years, for 10 years, everything goes well. But then that one fateful day, Mo comes running in the house. Mom, Dad, got a problem. You know that car accident I was in about 3 years ago? Well, it turns out that the folks that were in the other car got a judgment against me. And at the time of the accident, I didn't have the money to pay my premium on my car insurance. So I don't have any insurance coverage. Now, I'm a little bit concerned. I know that you folks put me on title to the house and on title to the bank accounts. Do you suppose that's going to be a problem? Well, not to be outdone, Larry comes running in the house. Mom, Dad, bad news. My wife's left me. She wants a divorce. She says she's going to take me for everything I've got. Now, was it about 10 years ago you guys put me on title to the house and on title to the bank accounts? Gosh, do you think that's going to be a problem? Well, how about you? You think that's going to be a problem? Well, yeah, it certainly can be. If mom and dad don't have the money to pay off Mo's creditors and Larry's ex-wife, they could end up having their house sold out from under them. They could end up having their bank accounts pillaged by the creditors, that is the folks who've sued Mo, as well as the predator, Larry's ex-wife. Now, we didn't mention Curly. Now, Curly is one of these very special beneficiaries that in the law profession, we refer to as the Babu's beneficiaries. Maybe that's not what they called it where you went to law school, but I went to U8, so we called them the Babu's beneficiaries. And Babu's, of course, means, well, to put it kindly, simple-minded. So Curly is a guy, he's never been able to pass a driver's exam, so he doesn't have a driver's license. He's single. He's a wonderful guy, very popular among his friends, but just not able to hold on to assets. So what joint tenancy could do for Curly is it could basically cause his parents to miss the opportunity to put special rules in place that will prevent Curly from blowing through his inheritance in a way that the parents would prefer he did not. So joint tenancy, we do use it in the estate planning world, but it's something that we need to be very careful about and use only advisedly. Now, there's a very special kind of co-tenancy between reciprocal beneficiaries, civil union partners, and spouses called tenancy by the entirety. And tenancy by the entirety has some very special attributes to it, especially under Hawaii law, because of the case Sawada versus Endo. What happened in Sawada versus Endo is that Mr. Endo, unfortunately, piled into a car full of Sawadas who sued him. And Mr. Endo went home and told his family, uh-oh, we got problems. And somebody advised them, well, you know what, Mr. and Mrs. Endo, you should transfer title to your house, to your kids, so that if you get sued and you don't have enough insurance coverage to make good on the lawsuit, then they're not going to be able to touch your house. Mr. and Mrs. Endo said, great idea. So they transferred the house to the kids. Well, eventually the Sawadas did get their judgment and they did come after the house, and they found out that the house had been transferred and they cried foul. They said, fraudulent transfer. You can't do that. You can't transfer away an asset in order to avoid a creditor's claim. Well, the Hawaii Supreme Court said, in this case, you actually can, because the Sawadas wouldn't have been able to touch the Endo's residence because they owned it in tenancy by the entirety. So our Supreme Court sort of exalted tenancy by the entirety to a very special status. And again, it's enjoyed by reciprocal beneficiaries, civil union partners, and spouses. Now, Sawada versus Endo itself dealt with real property. However, there have been subsequent cases, and the statute that talks about the creation of tenancy by the entirety actually provides that it's not just real property that you can hold as tenants by the entirety. You can hold any kind of personal property as tenants by the entirety as well. So at least in theory, you could hold your car in tenancy by the entirety. You could hold your bank accounts in tenancy by the entirety. Now, one of the incidents of tenancy by the entirety is that one spouse cannot unilaterally convey or encumber the assets. It takes both spouses or both reciprocal beneficiaries, both civil union partners, to make any transfer of tenancy by the entirety property valid. So the local banks won't allow you to open a bank account in tenancy by the entirety because generally they don't like the idea of requiring two signatures on every check, two signatures on anything that has to do with moving assets or dealing with your assets. Mainland financial institutions are a little bit less fastidious about that. So I have found that some mainland financial institutions will allow you to hold your brokerage account, other kinds of assets in tenancy by the entirety. So just be aware that tenancy by the entirety isn't just for real estate, it's for any kind of property you can own. And the two Hawaii cases that dealt with that were Dean Trust, and it's just dealt in dicta there, and it's a little bit more explicit in Estate of Ao. Now, a relatively recent development is that you can now take your tenancy by the entirety property and put it in your revocable trust without losing the tenancy by the entirety protection. There was a time in Hawaii when it was not completely clear, but if you did transfer your house, let's say, that was tenancy by the entirety with you and your spouse, and put it into your revocable trust or trusts, you probably or may have lost that tenancy by the entirety protection. Now, under a specific statute, you can transfer your house into tenancy by the entirety that you hold as tenants by the entirety into your trust, spouse's trust, or if you have a joint trust. The requirements are basically that the trust has to carry the first and last names of the marital partners or reciprocal beneficiaries or civil union partners. But it's a really cool way to be able to get the benefit both of holding assets in trust and having that creditor protection aspect of tenancy by the entirety. Okay, what is a trust? Well, trusts are really cool because they actually divide ownership of an asset between the legal or title holding component and the beneficial or the enjoyment component. The elements of a trust are these. Starts with a trust maker, same thing as a grantor, settlor, trustor. I call it trust maker because it's just kind of self-explanatory and it's not so legal sounding. But trust maker makes an agreement with a trustee to manage some stuff for the benefit of one or more beneficiaries. Now, we know that in Hawaii, same person can be trust maker and trustee and primary beneficiary of the trust. And most of the time when we set up revocable living trusts, that's exactly the way they work. So my revocable trust, actually, my wife and I are both co-trustees of my trust, and you can do that too. But I'm the trust maker, I'm a trustee, I'm the primary beneficiary. I have the ability to revoke or amend the trust. So I still have complete control over the trust. Now, in order for the trust to exist in the first place, something has to be entrusted. That's the stuff, that's the trust assets, sometimes called the corpus or the principal. Or if you're like me, you call it the stuff in the trust. And the deal between the trust maker and the trustee is set out in that portion of your rule book, also known as your estate plan, called your trust agreement. It can be called a declaration of trust. It could be called a trust agreement, trust instrument. Doesn't matter, what you call it, arose by any other name. That document is what governs your trust. It's the rules of how the trust assets are going to be administered, how they're eventually going to be distributed. Now, there's lots and lots of different kinds of trusts. Of course, there's testamentary trusts, trust created by a person's last will and testament. And generally, we don't use testamentary trusts anymore because in order for a testamentary trust to exist, your will has to go through probate. And probate is one of those things that we tend to like to avoid. But historically, there have been some very important testamentary trusts. The Bishop estate is governed by the will of Princess Bernice Pauahi Bishop, for example. Campbell estate was governed by a testamentary trust. But that was, I guess, back before the days when they appreciated that using your revocable trust using a revocable trust was a really good way to protect yourself in the event of incapacity. And we'll talk a little bit more about that. Now, the alternative to a testamentary trust is a living trust, one that you create while you're alive. A living trust can be revocable or it can be irrevocable. Revocable means you can change it. You can put stuff in, you can take stuff out. You are in complete control of your revocable trust. Now, the catch there is that whatever you can touch, your creditors can touch, your ex-spouse can touch. So if you hold assets in your revocable trust because you can get in there, because you can touch what's in your trust, third parties that you may not want touching your stuff can get in there too. But that's just how it works with a revocable trust. Irrevocable trust, on the other hand, takes your trust and puts a lid on it so that whatever's in the trust is protected from outsiders coming and trying to get through that lid, as long as you build the trust right, as long as you've got all the right rules in the trust instrument. So irrevocable trusts can be used for creditor protection. And as we're going to see, revocable trusts can provide creditor protection for not us, but the next beneficiaries in line after us, surviving spouse, kids, grandkids, whoever we want to benefit by way of our trusts. Now, something that we all need to be aware of is the adoption of the Uniform Trust Code. And this has been a couple of years already, but still, I find a lot of people don't really appreciate the fact that we do have this uniform law that doesn't dramatically change Hawaii trust law, but it does codify a few things, and it makes it provides some rules that we need to be careful to follow, like certain notices going out to beneficiaries and things like that. It's also taken the place of a couple of other statutes, one of them being the Uniform Trustees Powers Act. So what was in the Uniform Trustees Powers Act is now in the Uniform Trust Code. So if you have a trust agreement that says that the trustees' powers are all of the powers set out in the Uniform Trustees Powers Act, you might want to update that, and you might want to update your client's documents so that they refer to the current statute, which is the Uniform Trust Code. Okay, let's talk about some specific estate planning strategies. First of all, incapacity protection. Now, if your stuff is in your trust and you become incapacitated, it's still in your trust. So although you aren't in a position of being able to manage it and make decisions about it anymore, your successor trustee does have that ability to step in and do that on your behalf. Now, that's sort of one aspect of incapacity. Another aspect of incapacity is, well, right now I feel like I'm in pretty good shape to be able to control my trust, to make decisions and do all of those kind of things. But I've got to acknowledge that there could come a time when I lose that ability. And of course, we've all seen that happen. I've seen it happen in a situation where an individual developed Parkinson's, the Parkinson's bloomed into full-scale dementia. And this individual, shortly before his life, took a very large estate and made it a very small estate with some very bad decisions. There was nobody in the family. There was no mechanism for somebody to step up to the plate and say, hey, granddad, you really shouldn't be in charge anymore. Now, one of the kinds of things we can build into our trusts is what I call a disability panel. That is a group of people who can make the determination that I'm no longer competent to run my trust, and they can fire me as trustee of my very own trust. So, of course, I got to be very careful in picking the members of my disability panel. I've got to be very comfortable that these are folks that are only going to make that call for me if the facts really do dictate that for my best interest and for my family's best interest, I really shouldn't be trustee of my trust anymore. So that's sort of a subtlety to incapacity protection that can get lost in the shuffle, but something to consider building in. The alternative would be your family having to go to court and prove on the public record that you've lost your marbles and all of those kinds of things, which most of us don't really want to leave as our legacy. So making a private method of determination of incapacity can be helpful. It can be very attractive to a lot of our clients. Remarriage protection. I like to illustrate this one with a story. Fred and Wilma were sitting on their back lanai one evening, and it was a beautiful time of evening. The sun had just gone down and the trades had just begun to pick up. The birds had all found their nests in the trees. And Fred turns to Wilma and he says, Wilma, if I died, would you remarry? And Wilma about falls out of her chair. She said, Fred, what is going on? She said, oh, no, nothing. I'm fine. There's no health issue or anything like that. I've been thinking about this, and this is really important to me. I want you to know that if I die before you, it's perfectly fine with me if you remarry. Wilma says, okay, thank you very much, and turns to start enjoying the evening some more. But Fred, not to be outdone, a couple minutes later, turns to her and says, Wilma, if I died and you remarried, would you have your new husband come and live in our house? And Wilma says, Fred, I was just kind of starting to enjoy the evening. Do we really have to talk about this right now? Fred says, I'm so sorry. I understand, but this has just really been on my mind. I got to tell you, if I die and you survive me and you get remarried, it's perfectly fine with me if your new husband comes and lives in our house. And Wilma says, okay, thank you very much. A couple more minutes go by. Fred turns to her again. Wilma, if I died, at this point, Wilma's had enough. She stands up. She says, Fred, you have now officially spoiled the evening. I'm going in. You just enjoy it out here by yourself. Fred says, no, wait, Wilma, please wait. I got to tell you, if I die and you remarry, it's perfectly fine with me if your new husband uses my pickup truck. But I have one more question. Please, just bear with me. One last question. If I die and you remarry, will you let your new husband use my golf clubs? Wilma says, absolutely not. Fred says, well, you seem kind of certain about that. Wilma says, he's left-handed. Now, I have a little bit of an audience in there if you're here to laugh. And thank you, Tom, for laughing. I appreciate it. This is the first time I've told that joke in front of you. So the point is that most of us don't really want our stuff to go to our surviving spouse's next spouse and their kids to the exclusion of our kids. And most of my clients are like that too. I mean, I do have clients who say, I'm going to be dead. What do I care? But the vast majority say, yeah, I really would prefer that my spouse be taken care of after I'm gone. And if she wants to or he wants to remarry, that's fine. But eventually I want my stuff to go to my kids, not that other spouse's kids. So we can build provisions, we can build special rules into the trust instruments that say things like, well, if my spouse wants to get remarried after I'm gone, that's totally fine. But at that point, my trust terminates, the assets go out to the kids. Or you can be less drastic and you can say, well, spouse doesn't get to be trustee anymore. Spouse could be, let's say, an income beneficiary, could be a discretionary beneficiary, but they don't get to call the shots anymore. And one of the kinds of things that we might build in to the trust for protection for the spouse is power of appointment, where spouse, when they're done with the assets, gets to say where they go after spouse dies. And if we're concerned about remarriage protection, we can say, well, that power of appointment is limited to appointing assets to my kids, nobody else's. Or we could take the power of appointment away altogether. But the power of appointment is kind of a neat way to be able to allow surviving spouse to take a second look at the estate plan after the first spouse dies, because there may be circumstances that the surviving spouse really should take into account, like changes in our kids' circumstances, severe health problem. Maybe that child needs or could use a bigger share of the estate, or there may be reasons to write out another member of the family. So that power of appointment can be really valuable and really helpful to the surviving spouse in carrying out the overall wishes of the estate plan. Creditor protection is very easy to build into a revocable trust, where you're talking about protecting the next set of beneficiaries after the trust maker from their creditors. Among the kinds of things that would be helpful in building a trust that protects against the creditors of the next beneficiary, and the next beneficiary may be spouse, it may be kids, grandkids, but it's to limit the control that the next set of beneficiaries has over their inheritance. Remember, I was saying that that basic rule of debtor-creditor law is whatever the creditor can touch. Whatever the beneficiary can touch, the creditor can touch. Well, that applies after I'm gone. So if my wife can get into my trust any old time she wants, her creditors can get in there too. So how about this? How about I say that my wife can continue as a co-trustee of my trust after I'm gone, but she has to bring on board another co-trustee who actually is going to be the sole trustee that has discretion to make distributions to her. And I can give my wife the power to remove and replace that trustee at will, so that if the trustee turns out not to be that cooperative with my wife can change it. And typically in these kind of situations, we don't tell the wife or the beneficiary, whether it's child, spouse, whomever, we don't tell them who the distribution trustee has to be. We just tell them, you got to pick a distribution trustee. Now, from a creditor protection standpoint, what we'd want to do is make sure that that co-trustee is not the spouse, their parent, their descendant, their sibling, their employee, but it can be anybody else in the world. And the reason that those folks are frowned upon as trustees in an asset protection scenario is that the law presumes that we control those people. The law presumes we control our spouse, our parents, our descendants, our siblings, and our employees. And we all know that we don't control anybody. But in order to avoid the argument that the trust is simply illusory, what we do have to do is have a spouse or the other beneficiaries bring in a co-trustee that I like to call the independent distribution trustee. And as long as that distribution trustee isn't the beneficiary spouse, parent, descendant, sibling, employee, we have a better chance of that trust surviving any kind of attack by creditors. Similar principles apply when it comes to divorce protection. And sorry, I'm having a hard time making the screen advance. I don't know what's going wrong. There we go. So that we can be pretty sure that the stuff we leave behind for our kids is going to go to our kids. It's not going to end up in the hands of their spouses. Now, the kids have to really understand what was created for them, and they have to play along with the rules that we've set out in order for this to work. Because once kids start taking assets out of the trust, it's probably up for grabs in a divorce scenario. Now, none of these trusts are going to protect against certain kinds of creditors, including the IRS, including the state enforcing a tax lien or something like that. And maybe not even including a spouse enforcing some kind of a spousal obligation, or a child enforcing a parent-child obligation. But pretty much for other purposes, we can keep the folks out of our trust that we don't want to have in our trusts. Another consideration when it comes to the trust planning is avoiding creating issues for special needs beneficiaries. Special needs beneficiary, I'll define here as just someone who's receiving governmental benefits because they have some kind of a special situation. It could be physical, mental, whatever it is, but they're receiving governmental benefits because of their condition. Now, if you leave assets to a special needs beneficiary, you put that person at risk of losing their benefits, because once they're too rich, a lot of times the benefits are based on the person's assets and income. If you give the person too much worth of assets, and for most purposes, too much means $2,000 or more. If you give the person too much, they can lose their benefits and then basically be forced to burn through their inheritance and then try and requalify for those benefits, which they may or may not be able to do. So rather than disqualify special needs beneficiaries from receiving benefits, what tends to be a much better way to go is to provide in our trust agreements that anything set aside for someone who's receiving governmental benefits has some special rules attached to it. Among the rules would be that the beneficiary can never be a trustee, and that the trustee does have to be a neutral third party, like I described earlier. Now, that neutral third party can have the discretion to make distributions to the beneficiary for anything other than the kinds of things that the governmental benefits are already providing for. So generally, it wouldn't be for shelter, medical care, those kinds of things, but it can be for things that would enhance the beneficiary's quality of life. Things like a new wheelchair or a new bed or a computer or a TV, or even going on vacation. The government's not going to pay for those things, so the special needs trust actually can. So that what we can do through special needs planning is enhance the quality of life of the special needs beneficiaries. Yet another thing we can do with our trusts is promote our values. For some of us, staying clean and sober is a real value. For some of us, getting an education is a real value. Now, we can't necessarily prevent people from doing dumb things, but we can encourage them to do wise things, like go to school. How do we do that? Well, you're familiar with the old carrot and stick. You can provide carrots for beneficiaries who go ahead and get their college degree. In fact, we've done a couple of trusts for folks who have special rewards for their children when they graduate from college, when they get their master's degree, when they get their doctorate degree, so that the child, just by following in the parents' footsteps and going through those educational hurdles, can actually do pretty well on those distributions. And in the meantime, the trust is taking care of the educational expenses and like that. So these special distributions are those carrots to encourage that behavior. An example of a stick would be to build into your trust a provision that says, in order to get a distribution, beneficiary has to pass a drug test or has to prove that they're not using alcohol or those kinds of things. So requiring a test that the beneficiary is clean and sober in order to get a distribution is a way to encourage the beneficiary to do that. Now, not all beneficiaries are going to be able to or will do that. And if they can't pass the test, they don't get a distribution. And that's a very sad situation. But most of us would prefer to see our stuff go to things other than paying for our kids' drug habits or buying beer or whatever else it is. So just know that we can do a certain amount of values promotion as part of our estate plans. And the last thing I'd like to touch on is sort of the current state of federal and state estate taxation. The federal law provides a coupon. I call it the coupon. The IRS calls it the exemption equivalent, but it's kind of like the law gives each of us a coupon to be able to pass a certain amount of assets on estate tax free. Currently, the federal coupon is $12.92 million per transferor. As long as they're a US resident, they have that $12.29 million. Between mom and dad, they've got almost $25 million, almost $26 million worth of exclusion. Now, for most of our clients, that's more than enough. The annual exclusion, the amount that you can give away by way of gift and not have to report it to the IRS, is currently $17,000 per donee per year. So if your estate is greater than the $12.92 million and you want to shave it down a little bit, you can do so by way of annual gifts. And as long as they don't go over that $17,000 per donee per year, you don't even have to tell the IRS about it. And remember that the $17,000 is per person. So if mom and dad are working together on this gifting program, they can get a lot of assets out of their estate fairly quickly. Now, the $17,000 isn't necessarily $17,000 cash. It can be cash, but it can also be stock in the family business. It can also be fractional interests in real estate. And there's other things that come into play there, like fractional discounts and ways to sort of compress the value of what's being given away to increase the overall bang for that gift. Now, something to bear in mind is that although the coupon amount is very generous now and it's scheduled to continue going up, it only goes up through 2025. As of 2026, under current law, the coupon goes back down to $5 million as adjusted for inflation. And so there is the potential that our clients may be scrambling because although $12.92 million, most folks don't have, a lot of people in Hawaii have assets or have estates that are worth in excess of $5 million. So just something to bear in mind. Now, my best guess is that Congress is going to continue the current scheme of estate taxation. In other words, I don't think we're going to revert to the 5 million, but that's my word, and it's not worth very much in Congress. So we'll see what Congress does. But congressmen have estates too. And so I kind of suspect that the coupon will continue at a pretty high amount, but you never know. So just be aware that it is scheduled, the very generous coupon is scheduled to go away as of 2026. The tax rate on anything over and above the coupon is $40 million, which is why a lot of people want to plan to avoid the estate tax. I'm sorry, it's 40%. So that's why a lot of people want to plan to avoid the estate tax. So for every dollar over the $12.92 million, 40 cents goes to the IRS. And if you have a pretty substantial estate, you can see that that's going to be a pretty big amount of money. The estate tax is due within 9 months of date of death, and the IRS accepts cash. They do not accept chickens. They do not accept real estate. So liquidity planning can come into estate planning at times because whoever is left behind is going to need to have enough to pay the estate tax in order to be able to hold on to the assets. If it's a matter of having to sell real estate within 9 months of date of death, good luck. You're probably going to be in a fire sale situation unless the beneficiaries are able to borrow money or something like that. So just beware of that the tax is due within 9 months of date of death. Portability is a very important concept. It's something that is relatively recent to the estate tax world. And what it means is that when I die, even if I don't have $12.92 million worth of stuff, if my family files an estate tax return for me, my spouse can appropriate whatever portion of my coupon I didn't use, and then she can use that against her estate later on. So even if an estate tax return is not required to be filed by the law, a lot of times it can make sense to go ahead and file one just to have that portability. Now, Hawaii, of course, wants to be in on the act when it comes to estate tax. And there was a time when the Hawaii coupon was pretty much lockstep with the federal coupon. So when the federal coupon went up, the Hawaii coupon went up, and the Hawaii coupon was exactly the same amount as the federal coupon. No more. A few years back, our legislature decided that $12.92 million is way too much for any Hawaii resident to be able to skate by without paying Hawaii estate tax. So the Hawaii coupon is $5.49 million, significantly less than the federal coupon. It's still not an insignificant amount, but a lot more of our clients are going to have to deal with the Hawaii estate tax than with the federal estate tax. Now, Hawaii does not have a gift tax, technically. We sort of have a stealth gift tax in that the value of our estate for Hawaii estate tax purposes pulls in any taxable gifts we've made during our lifetime. So I mentioned the $17,000 annual exclusion. If you keep your gifts to your kids to the $17,000, there's not going to be any additional Hawaii estate tax. But if you go over the $17,000, what happens on the federal side is you start using up your federal coupon. So even though there may be no tax to pay, you got to file a tax return and you got to acknowledge that your coupon is being reduced. But Hawaii says, well, if you're going to be using up your federal coupon, we're going to pull that amount back into your estate for Hawaii estate tax purposes, and we'll catch you there. So beware when just planning for clients who've got assets in the $5 million range, that there's some pretty important things to discuss with the clients and to be aware of, so that we can help them minimize or at least postpone any estate taxes till both mom and dad are gone. Well, I promised to leave a little bit of time at the end for questions, and we've got about 10 minutes. So if there are questions, Desmond, if you want to go ahead and read them off, or I don't know if I'm able to.
I can read them off. So we do have one question in the chat right now. So does it work to give away all your assets, wait 5 years, and try to get Medicaid, etc.?
Well, that is one approach, and it depends on how you give away your stuff. But yeah, and this workshop isn't really about Medicaid planning, but generally speaking, if you apply for Medicaid, one of the questions is, have you given anything out our way in the last 5 years? If the answer to that question is yes, then what you can do is be disqualified from Medicaid for a certain amount of time. And there's a way to calculate the number of months. It's basically you divide the amount that you gave away by the annual or the average monthly nursing home expense, which under Hawaii law is $8,500. In real life, it's far more than that. You'd be very lucky to get away with paying only $8,500. But what happens is that's the number that's used to determine the number of months that you're disqualified. And the thing about it is the disqualification starts essentially when you're out of assets. And but for those gifts, you would have been able to qualify for Medicaid. That's when that penalty period begins to run. So the penalty period can be very tricky, and you want to be alert to that and be able to steer your clients around that. Now, as far as giving your stuff away, there are certain things that you can give away and not have any kind of a penalty period. For example, if your child lives in your home with you and they're actually providing care to you, you can give them your house as long as they've been there for 2 years. You can give them your house and not have any kind of a Medicaid downside. Now, there is a gift tax return probably that's going to need to be filed. Whether it be gift tax to pay depends on whether you've used up your coupon or not. But there are certain things that you can do. One thing you want to avoid doing that used to be very popular is giving away your stuff in trust. If you maintain any interest in the trust, you're probably going to be disqualified from Medicaid. So you got to be really careful about the way you make those gifts. Okay, Desmond, next question.
Yes, okay. If a revocable trust is not protected by creditors, would you recommend putting real estate into an LLC?
Yes, and of course, the only good legal answer to any question is it depends. But LLCs can be super helpful for protecting assets in the sense that the LLC can be built so they're very difficult for outsiders to try and get in. They're also can be very difficult for liability generated by the asset that's in the LLC to get out and affect other assets. Let me explain a little bit more what I mean by that. Let's say I own a condo that I'm renting out. It's a sort of a business asset. I put it into an LLC, and then I get in a car accident. And I don't have enough insurance coverage to pay all of the damages. The plaintiffs are going to be coming after whatever they can, including my rental property that's in the LLC. And depending on how that's structured, it may be very difficult for the creditor to get into the LLC. That's called outside-in liability. On the other hand, what if something bad happens at my condo and somehow it's my fault? Somebody gets injured and I don't have enough insurance on the condo to cover their damages. Well, they could go after the condo, and as long as I've set everything up the correct way and I've run everything the correct way, it may be very difficult for that person to get outside the LLC to attack my other assets. That's called inside-out liability, where liability generated by my asset can affect my other assets. So limited liability companies can sort of compartmentalize liability and protect from that outside-in attack. Now, one thing to be aware of with an LLC is if it's a single member LLC, which is very, very common, you probably don't get the same level of creditor protection as you would if there were multiple members of the LLC, including, possibly just spouse and kids or something like that. So for creditor protection purposes, LLCs can be really good. You just got to build them right and make sure that you have a good understanding of how creditors can get in and how asset liability can escape from the LLC and go after your other assets.
Okay, next question. My ADHC is 6 years old now. Do I need a new one? Do I need to do a new one?
Do you need to? Don't know. What we actually recommend to our clients is that they revisit their advanced healthcare directives every year. And it's not because advanced healthcare directives fall off the edge of the world, on a certain date. There's nothing in the law that says, well, once it's 2 years old, it's no good anymore. But it is one of those documents that's really good to revisit because our wishes about who we're going to want to have making decisions for us and maybe the kinds of decisions we want to make for us change over time. I know that my attitude about those kind of decisions really has over my lifetime, and I assume the same is true of my clients. But another thing about an older document, like a 5-year-old advanced healthcare directive, a 5-year-old durable power of attorney, is over time, those documents start to lose credibility just because they're so old. So updating advanced healthcare directives, durable powers of attorney every year is a really good idea, and that's what we encourage our clients to do.
Okay, next question. Is a Taiwanese citizen with Hawaii property subject to the U.S. gift tax if they want to convey an interest in Hawaii property to a relative?
Yes, but I'm sorry, Desmond, it was to a Hawaii relative?
Okay, let me read it again. So is a Taiwanese citizen with Hawaii property subject to the U.S. gift tax if they want to convey an interest in Hawaii property to have to a relative?
Okay, it depends on this is another one of those it depends answers. There is a way if you're gifting interests to non-US citizens, that you can sort of bypass the US transfer tax system. But as a general rule, yeah, you figure that there would be gift tax on the transfer, particularly if it's going to a US citizen or a US resident.
Okay, looks like we have two more questions in the box, and then we'll just take these two to close out today's webinar. But okay, so the next question is, does the widow's right of election, parentheses, a percentage based on the length of marriage, triumph over a trust?
Yes. But the way the elective share statute is worded is very problematic in a lot of ways. And I've never dealt with an elective share case where it was just crystal clear. This is how you calculate the augmented estate, which includes assets in trust and like that. Normally, those kind of cases just get settled when the parties just decide, yeah, this is the fair way to split things up. So putting property in trust doesn't avoid the elective share claim like it used to. There was a time when it did, but it doesn't anymore.
Okay. Actually, okay, so let's hear. Okay, will you say just a word about non-contestability clauses?
Yeah, I assume that's talking about what we learned in law school was called an in terrorem clause, one to strike terror into the heart of anybody who would try and contest my trust or my will. Hawaii law basically says that those kinds of clauses won't be effective if the claimant has probable cause for bringing their claim. So if one of my kids has probable cause for saying, well, dad just didn't have both oars in the water at the time he wrote that trust or that will that left me out, the non-contestability clause may not be effective. But there's a lot of ways to build non-contestability clauses in ways that they don't necessarily have to look like non-contestability clauses. So I think that's still fertile ground for smart lawyers like us to be able to figure out ways to sort of get around that probable cause standard regarding the contestability clause.
Okay, I know I said we were going to take those last two questions, but I think we still have time for one more, and there's one more in the chat. Okay, so this question is, so much sibling rivalry happens after their parents pass. Can parents put something in the will or trust that if any child gets into a disagreement and try to contest it, they will be cut off from their share?
Yes, absolutely. And we put it into virtually every trust and every will. But you have the problem, like I said, that under Hawaii law, if the person making a claim of undue influence or incapacity or those kinds of things, as long as they have probable cause, they don't have to win their case. They just have to have probable cause. The contestability clause will not be enforced. So there may be other ways, as I was suggesting, clever lawyers can come up with other ways to deal with that. And so that's something for us to think about and work with our clients about.
Okay, looks like all the questions have been read through. Thank you everyone for joining. Thank you, Scott, for giving your presentation on asset protection. And do you have any final words to say?
Yeah, thank you so much. I really appreciate people actually sitting there and listening to me for an hour. I don't know why you did that, but thank you. Next month, on July 6th, our next coffee hour has a special speaker, Jane Burigsai, who is going to be talking about Social Security, giving us the federal update. So that's really important stuff because Social Security has been in flux. There's new rules and new things we need to know. So I'd really encourage everyone to turn out for that talk as well. So thank you so much for being here.